Docket 1168 WME Motion to Seal. Dear Judge Lyman, pursuant to Rules 1C and Attachment A of Your Honor's Individual Practices in Civil Cases, non-party William Morris Endeavor Entertainment, LLC, WME, respectfully requests that this court order the continued sealing and redaction of certain confidential, personal, and non-public information contained in certain exhibits attached to Wayfair Studios, LLC. Justin Baldoni, Jamie Heath, Steve Sarowitz, It Ends With Us, LLC, Melissa Nathan, the agency group PR, LLC, and Jennifer Abels, collectively, the Wayfair parties, motion for summary judgment, and Blake Lively's opposition to the Wayfair parties' motion for summary judgment. Both motions attach as exhibits materials that were produced by WME in discovery that were designated as confidential. WME's proposed redactions are available in exhibits to this letter motion. Footnote 1. Pursuant to this court's August 12, 2025 order, the parties will redact all personally identifying information in the form of personal phone numbers and email addresses associated with WME contained in exhibits to the Wayfair parties' motion for summary judgment and in Ms. Lively's opposition motion. 1. Standard. In determining whether sealing is appropriate, the courts in Second Circuit apply a three-part test described in Lagash and Pyramid Co. First, courts determine whether the documents at issue are in fact judicial documents to which the presumption of access attaches, meaning that the documents are relevant to the performance of the judicial function and useful in the judicial process. Second, if the documents at issue are judicial documents, then courts determine the weight of the presumption of access, which varies based on the document's importance to the judicial function and its value to those monitoring the federal courts. Third, court balance competing considerations against the presumption of access, including the privacy interest of person resisting disclosure. Lagash. See also United States v. Amadeo. The privacy interest of innocent third parties should weigh heavily on the court's balancing equation. Such interests establish a venerable common law exception to the presumption of access. 2. Non-party WME's privacy interest outweigh the public's interest in the redacted information. In evaluating non-party privacy interests, courts consider both the degree to which the subject matter is traditionally considered private rather than public, as well as the nature and degree of the injury to which the party resisting disclosure would be subjected were the privacy interest not protected. The latter inquiry entails consideration not only of the sensitivity of the information and the subject, but also how the person seeking access intends to use the information. For example, courts have the power to ensure that their records are not used to gratify private spite or promote public scandal, and have refused to permit their files to serve as reservoirs of libelous statements for press consumption. Here, WME's privacy interests justify the requested redaction of certain private information in internal WME text messages. See Exhibits A through C. The proposed redactions are narrowly tailored and seal only sensitive information that has at best minimal relevance to the court's summary judgment decision. Notably, there is no evidence that the WME employees participating in the communications have any personal knowledge of what happened during the filming of It Ends With Us. In fact, they did not. Instead, the basis of WME's knowledge in connection with the proposed redactions was statements and information conveyed to WME by Messrs. Baldoni and Heath without independent verification or investigation by WME. Thus, WME requests to redact statements that merely advance second and third-hand knowledge. Moreover, WME employees are agents and advocates for their clients, and the communications reflect advocacy based on information conveyed to such employees by their clients. As such, the proposed redactions constitute confidential communications made in an advocate capacity, based on statements made by Messrs. Baldoni and Heath, which are not based on personal knowledge and therefore offer no independent corroboration. Accordingly, the redactions are inadmissible hearsay and thus ought not to factor into this court's ruling on summary judgment motions. See Leclerc v. Raymond, stating hearsay evidence cannot be considered in resolving the pending summary judgment motions. The statements may, however, gratify private spite or promote public scandal if published without redactions, which is exactly what this circuit warned to avoid, because the redacted material is largely collateral to the factual and legal issues central to the resolution of the Wayfarer party's motion for summary judgment. The weight of presumption of public access is low. Oliver Wyman Inc. v. Eelson, see also Amadeo, stating, the weight of presumption is low where the testimony and documents play only a negligible role in the performance of Article 3 duties. WME's privacy interests are high as redacted material is not already public. Specifically, the redacted communications involve Patrick Whitesell, Endeavor's then executive chairman, who has had zero involvement in this litigation. Mr. Whitesell was not deposed, has not submitted a declaration, is not listed on the party's initial disclosures, and is not mentioned in either the party's pleadings or the party's summary judgment papers. Given the minimal relevance of the redacted material and WME's privacy concerns, unsealing these communications will merely further the media-driven nature of this case. See SEC and Exchange Commission v. Ripple Labs, Inc., granting non-parties motion to seal summary judgment materials because the redacted identifying information was minimally relevant to the court's summary judgment decision and the substantial interest in witness safety and judicial efficiency overcome the presumption of public access. See also Oakley v. MSG Networks, Inc., granting non-parties motion to seal exhibit to spoliation motion given the email conversation therein was not relevant to any disputed material issue here. Accordingly, WME's privacy and confidentiality interests substantially outweighs any minimal public access considerations. See Securities and Exchange Commission, granting non-parties motion to seal portions of the summary judgment materials where the strong privacy interest of those resisting disclosure outweigh the presumption of public access. WME thus respectfully requests that the court permanently seal the specific portions of Exhibit 155 and Exhibit 244 to the Wayfarer party's motion for summary judgment and Exhibit 159 to Ms. Lively's opposition motion. Submitted herewith are redacted versions of Exhibit A through C. Additionally, WME understands that Ms. Lively intends to file a separate motion for the continued sealing of confidential information contained in certain exhibits, consistent with the privacy and relevancy grounds articulated above. WME joins Ms. Lively's motion to the extent it seeks full confidential communications between WME employees and clients who are not party to the case. Specifically, WME joins Ms. Lively's request to seal Exhibit 149, Exhibit 205, Exhibit 207, Exhibit 210, and Exhibit 211 to the Wayfarer party's motion for summary judgment, and Exhibit D and Exhibit E to the Wayfarer's opposition to Ms. Lively's motion. For Rule 11 sanctions, WME also joins Ms. Lively's motion to seal Exhibit 84 and Exhibit 85 to Ms. Lively's opposition to the Wayfarer party's motion summary judgment, as these documents reflect WME's commission rate. This information should remain under seal or be redacted because it is not relevant to any disputed material issue in this case. Respectfully submitted, Susan K. Leader. Exhibit A is a chat between Warren Zavala, Danny Greenberg, and Patrick Whitesell on July 22nd, 2024. Most messages are redacted. We'll read the ones that are not. Danny says to Patrick,
"Can discuss tomorrow."
Patrick replies,
"Danny, let's you and I discuss tomorrow."
Exhibit B is a chat between Danny Greenberg and Patrick Whitesell, dated August 10, 2024. Patrick says,
"Great news. Great job navigating."
Danny replies,
"Thank you. Wish I had more PW action. That's on me. I'll find it."
Patrick replies,
"Let's do it."
Exhibit C is a chat between Justin Baldoni and Danny Greenberg, dated December 30th, 2023. Danny says,
"Just checking in to see how the week went. Here to talk if you need me for anything."
Justin replies,
Hey man, had a really bad week. She had the audacity to email me directly and invite me to a meeting at her house alone if I chose. She's refused a body double, which now Sony and Todd have to jump in to make sure that happens, because that's just setting me up for a trap, although she's making me have one. She's rejected all of my storyboards for the scenes, so he has to get involved because she's trying to keep all of both of our clothes on for the big love scene, which is just ridiculous, if you know the book. The whole thing is just a gigantic cluster, and yet I'm doing my best to stay positive, although it's been very draining on me and time-consuming over this break to be dealing with an actress who is rewriting the writer and director. I've gone through the whole script. I'm giving her 95% of what she wants for peace, but this is just a brutal experience. We are all going to her house on Thursday, as that's where she has said the meeting needs to take place. She also doesn't want Jamie on set, which we are fighting back on.
Danny replies,
Good. You should. There has to be a line. I'll talk with Todd about that, and Warren too, if I need to.
Then Justin replied,
Not right now, but feel free to check in with Todd next week. I'm doing my best to just stay positive and give her as many wins as possible to just finish this thing, but it's going to be tough at some point. Warren needs to know that she is destroying her reputation. Where we will need the most help is during the edit, because I'm not going to get everything she wants, and I foresee that being a big issue. I won't even have time to barely show anybody the movie before I test it. That's what happens when you push the shoot till January.
the remaining texts are redacted.
Docket updates. Cut through the noise. Cut through the lies. Come to Docket updates. We give you the filings for you to